Good day, everyone, and welcome to the second webinar in the Convention Secretariat series of technical webinars celebrating the 20th anniversary of the WHO Framework Convention on Tobacco Control, or WHO FCTC as we know it. I am Adriana Blanco Marquizo. I'm the head of the Secretariat of the WHO FCTC. Please note that the video that you just saw is available in all 6 official languages on the Secretariat website, as are many other materials that you can use in your own celebration of our 20th anniversary. Since the WHO FCTC entered into force in 2005, we have achieved many life-saving tobacco control milestones stemming from the comprehensive implementation of the tobacco control measures that comprise the WHO FCTC. But while issues relating to liability are an important part of comprehensive tobacco control, as clearly stated in Article 4.5 of the Convention, the Conference of the Parties, or COP, the governing body of the treaty, decided at its session on February 2024 that additional efforts are needed to further the implementation of Article 19 on liability. The expert group established at that session is working on its report to the next session of the COP to be held in November. And we hope that today's webinar launching the multi-language version of the Article 19 online civil liability toolkit will provide you with additional tools in your efforts to support parties in further implementing Article 19. With that, I hand over moderation of today's webinar to my colleague, Kate Lang.
Thank you so much, Adriana, and welcome everyone. I suppose as the senior lawyer in the Convention Secretariat, I'm particularly excited about today's webinar. We're very, very pleased to be launching today our multi-language online civil liability toolkit, which will help parties who are seeking to explore furthering their implementation of Article 19 of the Convention. Now, the availability of this toolkit in all official languages will greatly broaden the accessibility of this extremely useful tool. So speaking of languages, let me first note that today's webinar is being interpreted live into all of the official languages. So please go to the bottom of your screen, your Zoom screen, and click on interpretation and select your preferred language. Now, we definitely have a packed program today, and we hope at the end of the session we're going to have a few times for questions and answers. No guarantees, but we'll try. So to that end, please type into the Q&A section any questions that you might have throughout the course of today's session, and we'll do our best to address those questions later during the webinar or at a later time. So first of all, please permit me to introduce today our first guest, who is Ambassador Viuli Dlamini of the Permanent Mission of the Kingdom of Eswatini to the UN and other international organizations in Geneva. Ambassador Dlamini was the chair of the previous working group on Article 19, and he's currently serving an advisory role to the current working group and has kindly agreed today to provide a few opening remarks. Over to you, please, Ambassador.
Oh, okay. No, thank you very much, Kate, for the introductions. And also, I wish to thank Adriana for the opening remarks. Colleagues, I will say greetings to all of you from your different jurisdictions, different times. Of course, some of you, it's in the morning, some it's in the evening. That is well acknowledged. Allow me to say from the onset that it is indeed an absolute pleasure and privilege for me to have the opportunity to address and welcome you all to the multi-language launch of the Article 19 online civil liability toolkit. We already know from experience that bringing claims against the tobacco industry is not an easy task. Governments, healthcare workers, and even many victims of tobacco-related illnesses have strong legal claims against the tobacco industry, but face uphill challenges to restitution, including legal obstacles and financial imbalances. Today, however, we celebrate another milestone in our collective efforts to help governments, individuals, and civil society overcome challenges in implementing Article 19 and bringing claims against the tobacco industry to court. By way of background, allow me to say that the toolkit we are launching today was developed by the expert group on the implementation of Article 19, which was established by the Conference of the Parties at its 5th session in September 2012 in Seoul, the Republic of Korea. And I'm greatly honored to have served in that expert group as the chair from 2013 to 2014. Following the work of the expert group, the toolkit was eventually adopted at the Conference of the Parties, the 7th session in New Delhi, India, in November 2017, as a mechanism to assist parties in their implementation of Article 19. Soon thereafter, the online civil liability toolkit was launched by the Convention Secretariat to serve as a practical, user-friendly, and interactive resource for all. Today, I am pleased to see that the excellent toolkit has now been made available in all official languages of the United Nations. This initiative is a testament to our continuing commitment to inclusivity in the tobacco control community, and in this instance, by making the legal complexities of Article 19 implementation more accessible to all. By providing this resource in multiple languages, we can ensure that valuable technical information is within reach of organizations, individuals, and countries across regions, thus enabling more effective implementation of Article 19 worldwide. On a related note, I am pleased to continue my work with the expert group in my role as special advisor following its establishment at COP10 in Panama in February of last year. The members of the expert group have since been at work working on a new report which builds on the information already available. I am sure many of you share my excitement and anticipation of this report, which will be presented at COP11 here in Geneva in November of this year. After this session, I invite you all colleagues to explore and make good use of the Article 19 online civil liability toolkit and to share the good news widely within your networks. By leveraging this toolkit, we can take greater strides in holding the tobacco industry accountable. Thank you for your participation and commitment, and I look forward to the guidance from our esteemed resource speakers in this webinar. Thank you very much.
Thank you so much, Ambassador, for those kind words, and of course for your past and your ongoing support for the work that we do. So turning then to what we can expect in today's webinar, we have 3 terrific additional speakers lined up to help us explore a number of issues. So first of all, we'll look at how the Article 19 toolkit can help parties implement their Article 19 obligations. And then we'll look to a particularly fascinating element of today's webinar, which will be to explore recent and current examples of Article 19 in action in 2 parties, in Canada and in Brazil. And then we will be providing you with an interactive walkthrough of how the toolkit can be used by all of us in our tobacco control work. So without any further delay, to take us through the substance of today's program, I'm pleased to introduce to you Professor Andrew Higgins, who is with the Faculty of Law at the University of Oxford, and he is the current chair of the Article 19 Working Group. Over to you, Andrew.
Thank you very much, Kate. Yes, my name's Andrew Higgins. I'm the Professor of Civil Justice Systems at the University of Oxford. I'm also a practicing barrister in England and Australia, and current chair of the Article 19 group. And I was previously involved in the earlier expert groups on Article 19 that helped develop the toolkit. And I also want to thank not only all the previous members of Article 19, but also particular Joanna Guzman, who worked for the Secretariat and then became a researcher working with me in developing this toolkit. I'm going to be very, very brief in my introductory remarks. So I do want to get to the country examples of litigation to give everyone an insight of what's happening. But first, I just want to explain why we set up this toolkit, which is essentially to provide a resource for people not just lawyers, but also people, policymakers, lawmakers, NGOs, thinking about ways of implementing Article 19 and bringing liability claims or liability actions against the industry, or indeed others who are responsible for the exposure to tobacco and or tobacco consumption. And what we're trying to do is, in effect, draw on the examples of practices that are widely available or have been adopted in tobacco litigation specifically, but also identify potential reforms that legal systems have adopted around the world to try and make their systems more accessible, and that parties may actually be able to implement themselves or leverage in order to make their systems more accessible, specifically for the purposes of tobacco litigation. So it includes examples of successful tobacco litigation against the industry, successful tobacco litigation in terms of getting the industry to change its behavior, stop misleading advertising, but also claims brought against the industry for damages, as well as healthcare cost recovery litigation. And what it's essentially trying to build around, can we have the next slide, please, if that's possible? What it's essentially designed to do is explain the kinds of reforms you need to sort of even up the playing field. As Ambassador Villiers pointed out, one of the real challenges in tobacco liability litigation is that the industry has enormous power and resources that are at its disposal to essentially thwart liability actions and delay them and deflect from the intention of their underlying conduct and the merits of claims, and deflect courts' attention from the wholesale damage that they've caused through their decades-long deceit and fraudulent business practices that have caused great harm to victims of smoking-related diseases, but also the society more generally. Next slide, please. And you can see, obviously, it's a terrific initiative that we've now been able to expand the toolkit into all the official languages of the WHO, and so I'm glad it will now be even more accessible than before. Next slide, please. And essentially what we did in the toolkit is try to build the resources around three main pathways, or three main forms of litigation that parties could take. And it's designed in such a way that everyone fully recognizes, working in this sphere, that not all parties will be able to take on, are at a point where they can take on the most ambitious claims against the industry, such as a healthcare cost recovery claim. So we've included a range of different scenarios that parties could think about reforming their laws for in accordance with Article 19 to facilitate different types of liability actions. And the first is healthcare cost recovery action, focused very heavily on the North American experience. The second is essentially opening up the civil justice system to facilitate or promote damages claims in the context of class actions or claims by individual victims of smoking-related disease. And the third scenario, which we think is probably the most useful for all countries, no matter what kind of legal system they have, or whether they're high-income countries or low-income countries, we think it's universally applicable, is the idea of public interest litigation. This is encouraging liability actions against the industry to, in a sense, enforce tobacco control laws or general laws that apply to the manufacture and marketing of tobacco products, to ensure that the industry is not engaging in misleading and deceptive conduct, for example, but also sometimes to enforce government's responsibilities to ensure that people are entitled to a smoke-free public spaces, smoke-free workplaces, and the like. So we'll hope to cover some aspects of all these three scenarios in today's webinar. The next slide, please. Okay, well, I'm going to, after we have our country presentations, I'm going to do an interactive walkthrough of one of the scenarios with some of the members. So we will I'll go to exactly how we mechanically use the toolkit, or as an example, but first I'd like to introduce our country speakers. And our first speaker is also a previous member of the expert Article 19 group, and that is Mr. Andre Lesperance. And Andre is a lawyer from Quebec. He's from a law firm that bears his own name, Trudel Johnson and Lesperance, and he was the lawyer, one of the key lawyers involved in the Quebec class action that has been on foot for a number of years now, but resulted in a successful liability verdict in 2015 from the Quebec Superior Court, which was upheld on appeal. And it was that verdict that led the Canadian industry to file for insolvency protection, and which has been ongoing for some time now. But that process is now concluded, or in the process of concluding, and it resulted in a $32 billion settlement, of which approximately 4 to 5 billion is going to go to Andre's class action class members. So without further ado, I'm going to hand over to Andre to explain the background to that litigation.
Thank you, Andrew. Maybe you can go to the first slide. Yeah, maybe the next one. So what is important for the audience to understand is how the spirit or the policy of Section 19 invite itself in our litigation. And that's going to give you some clue of the usefulness of Section 19, but how we manage it. So let's go back to the chronology really quickly. In 1998 in Quebec, it was in the air because of the master settlement agreement that there was going to be a class action against the tobacco. In the very same year, two independent, not coordinated class action were filed, one on addiction and the second on disease. And one important point here to know is the disease were chosen by their specificity to tobacco. It was lung cancer, throat cancer, and emphysema. Two things to remember. So really specific disease that where causation was easy to establish. And the second, that class action was driven by nonprofit organization, an anti-tobacco nonprofit organization that existed in Quebec since the 70s. So it was driven by doctors that were really wanted to put the tobacco company to their knees. 206, we have to get these class actions certified, meaning that we can represent essentially 100,000 victims for the disease and 1 million for the addiction. Authorized. Now, this is where the spirit of Section 19 comes. In 209, the government of Quebec, and we didn't see it, we were not warned about it, adopt cost recovery legislation. This is what Andrew talked about, where the government act to recover against the company for their costs, the healthcare costs. But they did something unusual. They gave us some tools in the spirit of Section 19 to facilitate causation. That happened in 2.9. Next slide, please. So 212, the trial lasts for 256 days. I remember because it was somehow painful with the tobacco, a very tough litigation. We finish in 214. We get a judgment in 215. We win. They go immediately to appeal. The appeal is heard in 216. And in 219, after 2 years and some months, the Court of Appeal rendered a massive decision, and we win on all fronts. And immediately after, they filed for bankruptcy, essentially, or rearrangement under the Canadian law. And 6 years after that, a fight with the province and the companies on how much we get, we have succeeded to have a plan of arrangement that was approved last month, which will be given to our members over 4 billion, and other victims in Canada 2.5 billion, and a foundation of $1 billion. Next slide. So what exactly is the issue and how did it help us? In any class action, the core issue is you cannot litigate against the company if you do it on an individual basis. You have to have collective recourse. That's why the province adopt cost recovery. And we said in court, we wrote, and it was reproduced by the court, outside of collective recovery, recourse of member against the defendant are just impossible, and the courts agree. So we had to do it on a class-wide basis. It was a challenge for us. We thought with the disease we chosen, we were able, but the cost recovery legislation or the spirit of 19 came to help us somehow. Next slide, please. So this is an extract from the Court of Appeal decision. And what it says here, dismissing the appeal and granting a remedy, we see that the legislator established specific rule to facilitate government recovery through the court of the cost of healthcare resulting from the fault committed by the company. But it also made certain other rules applicable to us. And what is the rule? Next slide, please. So the rule was in one section, one paragraph, 5 lines, and its proof of causation may be established on a sole basis of statistical information derived from epidemiology, sociology, or any relevant studies. It's just a rule of proof that allows us. In our view, that rule always existed. It never changed. You know, if you have lung cancer, you smoke tobacco, it is tobacco. But to have that in the law helped the court somehow giving us what we ask. Next slide, please. So one of the heart of the decision is paragraph 684.3, and it does reproduce section 15. And you could see that the court reminds the reader that section 15 exists. Again, the spirit of section 19 invites itself in our litigation. Next slide, please. This is the last one. Did the legislation facilitate collective recovery? Of course, it helped us. Would we have been successful without this? We think we would have. We would have done it, but it would have been a little bit more difficult because lawyers tend to see things in an individual basis. But tobacco is a collective problem, particularly when we deal with those diseases. There's no really other cause that exists. And you could see from the quote I've put there that I think the court was influenced by that, the provision or the spirit of section 19 that found itself in the section I just read. But I think we would have made a point, and there's some paragraph in the decision, we could have done it otherwise. But the core issue, the help of the government to us, it was a law for them, but they helped us with 2 provisions. And one of them was just saying the obvious. You can deal with tobacco on a class-wide basis. So that's pretty much my presentation. Any question will be, I'll be pleased to answer.
Thanks, Andre. That was terrific. I'm going to hand over to Davi Breslau of Brazil shortly, but just by way of introduction, that's an excellent example of both the advantages, but and I wouldn't say limitations of the toolkit, but qualifier or caveat we need to explain about the toolkit. So in the toolkit, we strongly emphasize the value of enabling legislation, including the sections and provisions that Andre has just shown you on the screen about being able to establish causation on a collective basis, for example, using epidemiological evidence without proof of individual causation. But there are countries that have been that are pursuing litigation against the industry without such enabling legislation, and our next speaker is from one of those countries, Brazil. So I think that confirms that this toolkit isn't exactly that. It's a toolkit. It's not an oracle. It's not the only way in which liability actions can be taken against the industry, but it is intended to be a valuable resource or starting point for people to inquire, think about ways in which liability actions can be taken. So Without further ado, I'm going to hand over to Davi Bresler, who is a lawyer with the Attorney General's office in Brazil, to explain the background to Brazil's healthcare cost recovery litigation.
Thanks, Andrew, and thanks for having me, everyone. Yeah, I'm here to talk a little bit about Brazil's case and here working as an example of a healthcare cost recovery. Next slide, please. So I also wanted to first give some background of what we are trying to do here. So we filed our case in May of 2019. So Brazil's Office of the Attorney General filed a lawsuit against the main tobacco companies in the country. So it was a work that involved like several years of preparation, and like several parts of Brazilian government was involved. A lot of lawyers, epidemiologists, public health analysts, and we filed this case against not only the Brazilian subsidiaries, but also the headquarters. So we choose to file the lawsuit also against British American Tobacco and Philip Morris International. That decision was made evaluating how these transnational corporations act in developing countries like Brazil. So with like national subsidiaries working as operational branches and where profits are sent abroad, and usually like there's some externalized costs that remains with Brazilian society. So the aim of the lawsuit is to recover funds spent on treating tobacco-related diseases, and the plaintiff is not only it is the public health system itself. So Brazil has a free and universal healthcare system, one of the biggest of the world, also similar to the UK model. So it is not a perfect system, but it serves as a model for several countries. We have like the system proved itself during the COVID pandemic, and it's a well-established system that deals with a lot of complexities of dealing with health issues across such a massive country as Brazil. So it is a big structure put in place, and the tobacco toll is massive on the system. Next slide, please. So the lawsuit that we filed basically has two grounds. First is strict liability and negligence. So Brazil is a country that follows civil law tradition. So civil liability is one of the parts of our civil code. And it's interesting to mention that like liability, they follow like general clauses in our legislation. So we have basically one general clause for negligence, but also one general clause for strict liability. And our general clause for strict liabilities are really like it has a lot of reach. Like it says something like that every company that produces damage through his ordinary operation, it's strictly liable for the damage. So it is a broad concept that we are using in our lawsuit. We filed a class action on behalf of the public health system. And but here it's like things get a little bit interesting, because actually it's called a class action, but we don't actually have like specifically a class. So Brazil legislation actually defends the existence of these so-called diffuse rights. So it's a concept that you can vindicate like basic fundamental rights without identifying precisely which persons are the ones that are affected by a damage. And for example, in our case, we understand that like every Brazilian is a plaintiff of the case, because every Brazilian suffers damage because they are the ones that are financing the system, and they are the ones that are using the system and like deal with these shortcomings because of tobacco consumption. So we have shortage of vacancies in hospitals and all sorts of issues, and some of those are due to tobacco consumption. So, and we see compensation for the treatment of 26 related diseases, and in something that we call it epidemiological causation here. So we are using mainly selected diseases upon the Surgeon General report of 2014. So we are only using diseases that epidemiology has already established causation. And we are seeking compensation in the percentage of the damage that is attributed to the product. So we are not aiming to apportion this cost upon persons. The reimbursement is to the system itself. So our understanding is that general causation, it's a bridge for us to reach like a percentage of the damage that should be reimbursed in the system. Next slide, please. And here I just wanted to make some quick comments about how, because I was also in the group that was building the toolkit, and it was part of evaluations of in our case. So I can testify of how its importance and also how it can be used. So the first thing, I think it's interesting that the toolkit, it makes it possible to it's a reminder for us that it's not only one route to seek liability. So there are options available, and you have to just take a time to evaluate your legal system. So I think that's a really good reminder that it gives us straight away. I think it has an important, it plays an important part of breaking down like huge tasks into smaller ones. Sometimes when you think of like filing lawsuits against the tobacco industry, you just like focus on the big picture and it seems impossible. But then when you start to break down step by step, you'll see that if you are able to solve one by one of these tasks, maybe you can feel that it's feasible. But knowing that every part is a relevant decision. So every part of the toolkit, every step that they propose it's a major one. So it is something that has been really been, have to be like pay attention to and carefully evaluated, because those are many of the cornerstones of tobacco litigation or any like complex liability litigation are there. I always say that sometimes answers give rise to another questions, but also the toolkit, it's a good example of the order to ask them, because here sometimes when you are facing such huge tasks, you get a little bit overwhelmed by it, but it gives you like a narrow path to evaluate your system. And this is also something that is really interesting. It does not provide all the solutions. It's not built to provide all the solutions. It's built to give to give different legal systems some ideas of how they should address their own peculiarities. So what things need to be addressed. And sometimes just knowing what to ask, I think it's already a big step. So even if it's the answer may not be fully there, even to know what the question is, it's a really important part. And finally, I think that the toolkit also gives you an idea of how a massive task is, so that also you have to be prepared for how difficult it be, how long it can be, how many setbacks you can have along the way. I think Andre is talking about decades-long lawsuit. We are here. We filed in 2019. We are 6 years in, and we are still in the issuing evidence and waiting for a first decision. So these lawsuits, they take long, and due to the complexity of it. And I think the toolkit also gives you an idea of like the huge challenge that it is. But also it gives you an overview of what is needed. So I think I wanted to end up on this note that it is something that should be used for countries, by countries. And it is it is a part of valuable resources that we have in the tobacco control. And so that's it. Thanks, Andrew.
Thanks very much, Davey. Extremely helpful presentation. There's things that jump out at me about those two presentations were both fascinating. Is that despite the very, very different structures of your legal systems and the different types of litigation that you're involved in, both are built around principles of collective proof. Everything's about collectivity. And I, like Andre, come from a legal system where lawyers think in individualistic terms. And to some extent, as Andre said, the enabling legislation was just reminding the court that it can and should do the things that it always should have done, which is be able to prove causation on a statistical basis, given that's how causation is normally proved in the real world. And yet in a country like Davi's that is so, I think, comfortable with the concept of collective rights, they can have a class action even without a class, to use Davi's language. So given that collective background, just would you give sobering advice to parties to say that you would never encourage individual action against the industry for damages?
No, I will not say so. I will say, in our understanding here, we have like really different kinds of rights and different damage from tobacco control. So, for example, in our case, even if we are successful, every smoker and their families can still have their own place. The damages are different. What we like to think is that in some countries, mainly civil law countries, and especially Latin American, we struggle a little bit with like this concepts of epidemiological causation. So we do have like a really favorable scenario for the tobacco industry regarding individual smokers. What we aim to achieve also with this kind of lawsuit here is trying to show judges how science is built and how are these causation measured in this kind of cases. And our hope is that like we can like see like waves of litigation afterwards, this making it a little bit easier for individual smokers, also using these concepts that are not so familiarized here in Brazil. And so, but yeah, I think that the challenge is different. That there are few more questions to be answered in cases of individual smokers, but some of the core understandings I think are still there. So they are I think that that's a good way to put our case as not a stepping stone, but it's like trying to lay some foundations for a different kinds of thinking that can help us deal with like non-communicable diseases that we do have like multifactorial diseases, and we have to rethink our structures of causation around the world. Otherwise, this will be like it's already our greatest cause of death around the world, and apparently like legal systems are still struggling to address it. And so our hope is that we can at least advance the discussion a little bit.
Andre, do you want to answer this?
Do you want me to delve into that issue, Andrew? No, I think I agree with David, but there is the elephant in the room is also financing those litigation, and doing an individual trial would be just out of proportion with the amount we would be asking. It would be essentially proving if, for instance, that they conspire to lie. We'll take 3 months, 6 months of litigation for an individual case. I don't know how you would finance those. And at the end, what you would establish would be what help everybody. So you could do an individual case if you find a lawyer that wants to, for instance, pass the essentially his lawyer's life on a case, and he has a lot of time and a lot of money outside of it. But at the end, it's a big fight. It's existential for the company. They're not going to allow an individual case to proceed ever. So, since you're getting to the fight, might as well get the real fight. But conceptually, you're right. You could do it individually, and do a lot of benefit to society by revealing the internal document, which is, when you read them, you just can't believe what you read.
Thanks, Andre. It's very well said. I think that I think one of the lessons of tobacco litigation is that collective action, class actions, is one of the best ways to achieve what European lawyers would call equality of arms between the parties, given the how well resourced the tobacco company is, and if it's action by an individual, they have the resources to engage in lawfare or scorched earth tactics. So, Kate, can we move now to the interactive walkthrough, and then we'll come back to open up to questions if possible.
Yes, indeed. And thanks so much to Andrew, Andre, and David for eliciting those really important details in terms of Article 19 type litigation. But of course, exploring these cases raises the question, how can each of us, so each of the people listening today, explore similar Article 19 implementation in our specific jurisdictions? And of course, the answer is that the multi-language Article 19 toolkit is geared to help support you in that analysis and to answer that question. So to help us today in taking an interactive walkthrough of the toolkit, along with Andrew on how to use Article 19 toolkit, is Ms. Lily Lee. Lily works with the Tobacco Free Initiative team in WHO's regional office in the Western Pacific, which is, of course, based in Manila. Welcome, Lily. Would you like to join us?
Thank you, Kate. I hope you hear me well. So
We do
hello,
indeed.
everyone. Thank you. Hello, everyone. I'm Lily, and I work for Tobacco Free Initiative team under the NCD Prevention Unit at the WIPRO, as Kate introduced, based in Manila, Philippines. Thank you for having me for this very important and interesting webinar. As all 27 member states in our region are parties to the WHO FCTC, our office provides support to all of these parties in implementing the FCTC. While we've made significant progress implementing many articles of the treaty, Article 19 on liability remains one of the most challenging and underutilized articles. So I'm very excited about today's webinar and about this toolkit because we've seen growing interest in using legal mechanisms to advance tobacco control. I look forward to learning more about how to use this toolkit in navigating the complex areas of tobacco liability and options countries may consider. Thank you.
Brilliant. Thank you, Lily. Thank you for volunteering your services. Kate, can we go through to the toolkit slide, please?
It should be loading up momentarily.
Okay, thank you. All right. So what we're going to do, can we go to scenario 3, please? Okay, so as I briefly mentioned at the beginning of this webinar, scenario 3 is that scenario that we thought is perhaps most suited for all countries around the world, because the challenges that Andre and Davi have been talking about in terms of scenario 2 and scenario 1, healthcare cost recovery action or collective redress actions against the industry, are all about redress. And one of the key challenges is proving damage. And we've been discussing at length about how to do that and the challenges of doing that. But scenario 3 often proceeds from the basis that there's no need to prove damage, because in effect, what we're trying to do is essentially just enforce the standards, ensure that the tobacco industry is complying with the general laws or the tobacco specific laws in a particular country, and then working out how best we can enforce those laws through liability action. So we begin with the very first question, which I'll throw to Lily. In your country, are there suitable tobacco control laws or general laws that apply to the manufacture, supply, and marketing of tobacco products? And I hope there's a clear answer to this question, but we'll see.
Yes. In most parties in our region, yes. I believe all of our member states have some forms of tobacco control legislation, though they vary significantly in their comprehensiveness.
Right, terrific. All right, so when we just tick yes, and then we move to question 2. And then the next question is, great, we have laws on the books, but do we have enforcement mechanisms? Are there ways to enforce these laws to ensure that those bound by them, in the industry in particular, actually comply with their legal obligations? And I should also say, when we talk about enforcement mechanisms, one aspect is fines, imposing fines for breaches, but also another very important enforcement method is obtaining injunctive relief, or what a technical lawyer word for just getting an order from the court to get the industry or the defendant to stop doing something, or to actually do something. In most cases, to stop engaging in misleading conduct or correct misleading statements by issuing a correction of things of that nature. So over to you, Lily. Do you have enforcement mechanisms behind the laws?
Yes, that's also the case in most parties in our region. Of course, there are some variation again across countries, but I understand most tobacco control laws include provisions for penalties, and some include mechanisms for injunctive relief too.
Right, thank you. All right, so we tick and on we go. Now, the next question, which we think has been which we identified as a common theme to success amongst parties who've taken action on this in this field, and from different parts of the world too, is asking whether or not the legal system allows NGOs, or indeed any members of the public, to enforce tobacco control laws or relevant general laws, to bring claims directly to enforce the laws against the industry. So over to you, Lily. What's the position?
I don't think so, at least not consistently across our region. And I think this is something very significant challenge we've identified.
Okay, great. So at this point, we would tick no, and the toolkit would then move us on to the next question about whether or not it's possible to amend the standing rules. Now, the idea behind these standing rules is to recognize that, in effect, the law sets universal standards that those subject to the regulations must comply with, and there's a recognition that for one reason or another, sometimes the relevant law enforcement agency doesn't have the resources, doesn't have the time to be able to enforce all laws, and or doesn't have the budget, in effect, to take on an industry that often dwarfs the resources that are available to the regulator. And one way to, in effect, open up the possibility of enforcing these laws is to open up the enforcement process to everyone, so that everyone can, in effect, become what we might call a private attorney general, to act as a regulator in the specific instance of enforcing these laws. And one of the challenges about that historically is that the industry would say, well, this is just some private citizen, why are they complaining about the law? And so one of the priorities is to pass standing rules that allow these ordinary citizens, or qualified NGOs in some cases, to bring these actions. So without further ado, over to you, Lee. Is it possible, do you think, in most of the countries in your region, to amend the laws, or might be possible to amend the laws to actually open up standing to
Yes.
NGOs and or citizens?
Yes, that should be possible in most parties.
Okay, great. So we tick yes, and then we would move on. And this is what we have tried to do, is we recognize, and I think Darby touched on this in his presentation as well, we recognize that no matter what pathway you're in, there are just some universal challenges in tobacco litigation that all legal systems face. Some systems are just slightly better equipped to do it than others, given almost fortuitous history, whether it's a civil law country or a common law country in the global north or the global south. But often, almost every system has some weakness that an industry will exploit. And in question 5, we're turning our attention to the kinds of reforms that all legal systems need to at least think about in order to strengthen their liability system. So here we're asking questions that, are there other reforms that your legal system could implement to reduce the power imbalances between the industry and potential claimants, so that in effect the industry can no longer engage in delaying tactics. And here, if you look down at the explanation, you can see live links to different checklists that we've developed in terms of forms of living on the merits, to stop delays. That litigation can be done within a reasonable time and at proportionate cost. So if you just clicked on it, proportionate cost, for example, right. So this will bring up, I should say, a checklist of reforms that parties could consider to make their systems more accessible. And these are all about amending cost rules. So if we just scroll down that page for a little bit, I can give you an example of different types of cost rules. Now, again, I want to stress the point that's come through this entire webinar. There are different ways you can achieve, you can implement cost rules to ensure that effectively the industry can't out-litigate someone, or you can provide sufficient resourcing to allow parties to take on the industry. So we've got here examples such as capping cost liability, so that people who sue the industry aren't open to open-ended liability against if the case is unsuccessful for whatever reason. You can provide court fee remissions for those who have limited resources. And then thirdly, and importantly, and I think Andre's touched on this as well, legal systems need to think about contingency fee reforms to enable lawyers in their countries to take on actions in a way that effectively to finance them, so that in the case of Andre, I think he litigated for at least 15 years. I mean, I'm sure he's not counting, but it's well over a decade. And it's just very difficult for any private law firm to do that and carry that economic cost. And one way they can do it is where you have contingency fee arrangements, so that there is a percentage fee associated if the claim is ever successful. And an important point to stress is that if the claim is unsuccessful, Andre would get nothing, and the lawyers who act on this basis would get nothing. So they are in effect risking their own labor. But of course, if the claim is successful, then a percentage of the recovery is then payable to the law firm. So these are just different reforms we've suggested, just one of the checklists as an example. And right at the end, we've also talked about the idea of whether or not it's possible to enforce judgments in foreign courts, particularly in those countries where the industry may not actually be based in the region, but in fact have headquarters elsewhere in the world. And the idea of this is another reform that countries need to think about to ensure that they can enforce judgments against the industry. So if we close that checklist, and then if we just Lily, what's the answer to this question 5? Do you think other reforms would be desirable or needed in the countries in your region?
Sure. I think there are reforms in these areas that would have to be made in most countries in our region. So any resources such as the checklist that you just showed would be really helpful.
Okay, great. So we'll tick yes. And then we move on. Right, and we are at the end of our pathway. And then you can review it. You get your own report to indicate the process you've gone through. If you just scroll down, if the secretary could just scroll down for me. And what we did in the reports, we also try to do is just take you through the key points we've just been discussing, but we also tried to give some helpful resources. So in that we've given some case studies of instances in different countries that have used this idea of opening up standing to non-regulators, to in effect either qualified NGOs in the case of the French example, or the Australian example to everyone. Or, I mean, for example, let's click on the India example as a example from the global south of what the Indians do in public interest litigation. So in India, we've got a case from the Supreme Court of India in which it adopted a liberal standing rule which it said, a very neat quote. It says the relevant principle is that where rights are of fundamental importance and the persons who have those rights have difficulty accessing the court to enforce them, anyone is able to file a claim on their behalf. So in other words, where you have a marginalized group that have difficulty accessing the court, then in effect, anyone can turn up to the court and try and bring a public interest claim on their behalf. And there you've got the quote from the relevant court decision. And in that case, the public interest litigation suit was filed to require the government to enforce a ban on smoking in public places, to in effect enforce an important provision of the Indian Constitution, in Article 21 about the right to life. So here's an example of a specific, India has a post-colonial constitution, it has very strong constitutional rights, and it's a way in which the Indian legal system has developed its procedural rules to promote access to justice, and in this case, it's been implemented to actually, in effect, force the government to introduce laws that will reduce people's exposure to tobacco, just as an example of the ways in which public interest litigation can be used to pursue Article 19 related goals. All right, I think we're nearly done. So I wanted to hand back to Kate, who can take the floor now and hand over to Q&A if need be, or wrap it up. So thank you, Lily. That was extremely helpful. And thank you again to Davi and Andre for their presentations.
Thank you, Andrew, and thank you so much, Lily, for your participation as well. So we have had a few questions, but of course, mindful that we're a bit over time now. There was one question in particular that sort of looks at an area that we haven't necessarily touched on yet that perhaps our speakers could give their thoughts on. It's an interesting question and of course deals with an important stakeholder in tobacco control activity. The question is, in relation to Article 19 and affirmative liability actions, could you comment please on how civil society could best assist parties in those efforts? So I wonder if we could ask each of our speakers to give a short response to that question in their view. Maybe starting with Andre.
I mean, how can civil society help in a tremendous way? In our file, it was a nonprofit organization, NGO, that thought about this our class action 26 years ago. But for their dedication and help and actually gathering the people around the idea, we wouldn't be here today. So it was driven by civil society, and today we're benefiting from the effort. It was a collective effort. So I don't know if that answered your question, but in our case, it was.
Thank you. That's very interesting. Davi, do you have a comment on it as well?
Yes, I do. And in our case, I think it was really meaningful, the participation of civil society, especially like to bring information from past experiences to us. Like there are countries like from Canada, the US, so this litigation has been happening many years. And there's a lot of history there, both on the courts and off the courts, of the work that has been done and how things proceeded. So I think that was a really important way for us to try to understand the task that we were facing, but also like to absorb this knowledge that has been built inside of this civil society organization that has many years of contact with tobacco industry and with litigation. So I think it was really fundamental for us, like this exchange of ideas and try to like foresee a little bit of what's ahead of us.
Thanks so much, Davi. And Andrew, you of course have experience in this area as well. Do you have any comment on the role of civil society?
Yeah, I mean, I would just echo what's just been said. I mean, if you think about all the resources I've ever used in tobacco litigation, whether it's document depository archives maintained by the University of California, San Francisco, or the campaign for tobacco-free kids, tobacco litigation databases, all the resources that are used by the lawyers to work out what the industry is doing, right, and collect all the information the industry has been tactics they've been engaged in over decades. In some cases, the evidence they've been destroying over decades. All that information is often coming from civil society initiatives, civil society programs hosting that information. And to some extent, the obligations under parties on Article 19 to cooperate with each other and provide assistance. It's the first port of call should really be the civil society in terms of all the initiatives that they've developed and taking a leaf out of their book to in effect improve cooperation between the parties, because once you've got that information exchange, and the toolkit is an important initiative in that regard, it does reduce the information asymmetry between those taking on the industry and the industry.
And Kate, if I might add one point, the civil society was in a war room during the trial, and they provide, just as Andrew said, if it would be for Cynthia Keller and Neil Kalisha, we wouldn't have done it. And they come from civil society, and they had the knowledge and information to help us go through this difficult task.
Thank you so much for the response to those questions. Really, all of the information we've heard throughout the course of this webinar has provided incredible food for thought, I think, for all of us, for all of the audience. So just to conclude, first, a huge thank you to our audience for joining us for today's learning opportunity. And I'm sure all of you will join us in thanking very, very warmly our terrific speakers, starting with Ambassador Dlamini, and then, of course, Andrew, André, and Davi, and thanking them also for their continuing work in this space. Thanks also to our interpreters, without whom this multi-language event today would not be possible. Just to let you know, everyone, that the recording of this webinar will be uploaded to the YouTube channel of the Convention Secretariat in all of the official languages. In addition, each registrant will receive a link to the video and also a link to the multi-language toolkit. So you'll have everything right at your fingertips when you need it. One final note of advertising for the Convention Secretariat. Please recall also that there is the Article 19 database of experts that is up on our website. And we would like to remind all parties and also civil society to please make sure that relevant experts are added to this database, contacting us or the focal point in your particular party in your jurisdiction. So with that, I again wish everyone a very warm thank you. Thank you so much for your participation, for the excellent discussion that we've had today. Hoping everyone has a fantastic rest of your day, and wishing you goodbye from Geneva.